Hello and welcome to the discourse on right to legal aid and assistance for the accused persons. Friends, the moment the right to legal aid and assistance for the accused person is under discussion, one will certainly take to Article 22, Clause 1 of the Constitution of India, which provides inter alia that no person who is arrested shall be denied the right to consult and to be defended by a legal practitioner of his choice. A corresponding provision is the Code of Criminal Procedure 1973 at section 41D, where any person is arrested, he is entitled to meet an advocate of his choice during interrogation, though not throughout the interrogation. But when an accused person is unable to afford an advocate on hire, then the proceeding against him would be vitiated due to non-representation of a lawyer to defend the accused. It is the civilized norm of the Indian society that a person cannot be condemned unheard or unrepresented. The Constitution itself, as well as some ordinary legislations and some decisional laws, make provision of legal aid, particularly for the accused person. So this study shall confine to only this aspect, that is, right of legal aid and assistance for the accused persons. The concept of legal aid sprouted from the principles of natural justice called odi alteram partem, that is, none should be condemned unheard. The civilized norm of administering criminal justice is that justice should not only be done, but should manifestly shown to have been done. On one hand, India is a republic committed to secure to all its people social justice, and naturally a provision of giving legal aid to the poor and indigent persons is a necessity without any alternative. There have been numerous cases where injustice have shown that the accused being convicted without proper defense by counsels. An example can be taken from Manipur state. The oldest case record showing poor representation of the counsel for the accused in judicial proceeding was Queen Empress versus Tikendrajit Bir Singh, which is reported in documents Anglo-Manipur War, Volume 2, First Edition, 1991, page number 2. The trial of Tikendrajit Bir Singh was conducted by a special court comprising 3 British officers, of whom 2 were military officers and 1 being a civil servant. He was tried on the charge of waging war against the Queen Empress and abatement of murder of the 4 British officers. In that trial, a request was made on behalf of the accused for allowing him to be represented by a legal expert to be requisitioned from Calcutta. However, it was turned down by the court. Therefore, after the case being proceeded without the aid of any counsel, the accused made another application to the court to allow him to be represented by one layman, Mr. Janikinath Bosak. The application was allowed. The said Bosak was a Bengali utensil trader who was absolutely without any legal background. The only consideration for his appointment as a counsel was that he could follow English language and spoke a little of Manipuri language and was the only person available at the time to communicate the court and the witness by interpreting and translating English into Manipuri language throughout the proceedings. He had represented the accused after examination of 10 prosecution witnesses. Before his representation of the accused, the case was proceeded without the aid of counsel. The accused was convicted and sentenced to capital punishment. So this is a glaring example of injustice to an accused person if he is viewed through the lens of the Constitution, which aims at doing social justice now. Section 304 of the Code of Criminal Procedure 1973 lays down the provision of legal aid to the accused at state expense in certain cases, where in a trial before the Court of Session, the accused is not represented by a pleader, and where it appears to the court that the accused has no sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. Under the said provision, the High Court may, with the previous approval of the state government, make rules providing for: number 1, the mode of selecting pleaders for defense; secondly, the facilities to be allowed by the court to such pleaders; thirdly, the fee payable to such pleaders by the government. And the state government may, by notification, direct that, as from such date as may be specified in the notification, the above provision shall apply in relation to trial other than before the Court of Session. In pursuance of this provision, the courts have been appointing counsels to defend the undefended accused persons, and the counsels so appointed, which came to be known as amicus curiae. Article 39A of the Constitution of India has made provision for equal justice and free legal aid. The provision has been inserted into the Constitution by the 42nd Amendment Act 1976 with effect from 3rd January 1977. Before this amendment, there was no express provision for free legal aid. It is a mandatory duty to secure that the operations of the legal system promotes justice on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to secure that opportunity of securing justice are not denied to any citizen by reason of economic or other disabilities. An important impact of Article 39A read with Article 21 of the Constitution has been to reinforce the right of a person involved in a criminal proceeding to legal aid. The article has been thus used to interpret and even expand the right conferred by Section 304 of the Code of Criminal Procedure 1973, which will be discussed in the judicial approach of legal aid to the accused persons. The Legal Services Authority Act 1987 is an act to constitute legal services authorities to provide free and competent legal services to the weaker sections of the society, to ensure that opportunity of securing justice are not denied to any citizen by reason of economic or other disabilities, and to organize lok adalats to secure that operation of the legal system promotes justice on the basis of equal opportunity. This is the national law on the provisions of legal aid, and Section 12 of the Act provides for entitlement to legal services. It is provided that every person who is to file or defend a case shall be entitled to legal services under the Act. Therefore, the right of an accused person to avail of legal aid is clearly enacted under the Act. As for an accused person, it is enacted that every person who is in custody or whose annual income is less than rupees 50,000 is entitled to legal service. The term legal service denotes and includes the rendering of any service in the conduct of any case or other legal proceeding before any court or other authority or tribunal, or giving of advice on any legal matter. In giving effect to the concept of legal aid as applicable to the accused persons, many states have taken up steps to assist the person arrested and are produced before the magistrates. For example, in the state of Manipur, every magistrate's court is deputed a council called the Legal Aid Council by the Manipur State Legal Services Authority under the Act. Any person arrested, produced before the magistrate, is to be informed about the service of Legal Aid Council so that the possibility to make bail applications, remand objections, and other applications by the accused persons is not denied, because no counsel was formally appointed by them due to penury or due to impossibility to arrange a counsel as he is in the custody of the police. These legal aid councils are paid by the Legal Services Authority and work in the best interest of unrepresented accused persons produced before the magistrates. This provision of making available of the services of the Legal Aid Council to the accused person works practically in the interest of the accused person, and it becomes a popular scheme of legal aid to the accused person at the initial stage when first produced before the magistrates after their arrest. In a recent case, the Supreme Court, after reviewing numerous cases of the domestic, international, and the constitutional and statutory rights of an indigent accused to avail free and competent legal aid, pointed out the duty to the trial court to provide the same. The case of M.D. Ajmal, M.D. Amir Kasab versus State of Maharashtra, AIR 2012, Supreme Court 3565. The court imposed mandatory duties to the magistrates in the matter of providing legal aid to the accused person. It is further held that the duty of the magistrate before whom a person accused of committing a cognizable offence first produce to make him fully aware that it is his right to consult and be defended by a legal practitioner. In case if he has no means to engage a lawyer of his choice, that one would be provided to him from legal aid at the expense of the state. The right flows from the Articles 21 and 22, Clause 1 of the Constitution, and needs to be strictly enforced. The Supreme Court accordingly directed all the magistrates of the country to faithfully discharge the aforesaid duty and obligation. The court further made it clear that any failure to fully discharge the duty would amount to dereliction in duty and would make concerned magistrate liable to departmental proceedings The question is again, what would be the legal consequence of failure to provide legal aid to an indigent who is not in a position on account of indigence or any other similar reasons to engage a lawyer of his own? In this regard, the court held that every accused unrepresented by a lawyer has to be provided a lawyer at the commencement of the trial. Even if the accused does not ask for a lawyer, or if he remains silent, it is the constitutional duty of the court to provide him with a lawyer before commencing the trial. This duty is absolute, and failure to do so would vitiate the trial and the conviction as well as the sentence. The court went on further. Consequences that will follow for failure to provide a lawyer to the accused at the pre-trial stage. The court held that will not have the same consequences of vitiating the trial. It may have other consequences like making the delinquent magistrate liable to disciplinary proceedings or giving accused a right to claim compensation against the state for failing to provide him legal aid. But it would not vitiate the trial unless it is found that failure to provide legal assistance at the pre-trial stage had resulted in some material prejudice to the accused in the course of the trial, which would be judged in each case. It is well settled by the judicial pronouncements that the right of the accused person to legal aid in the proceeding against him is absolute. The right to legal aid of the accused is a fundamental right and also a basic human right as defined in the Protection of the Human Rights Act 1993. The court has insisted in clear terms that a procedure which does not make available legal services to an accused person who is too poor to afford a lawyer and who would further have to go through the trial without legal assistance cannot possibly be regarded as reasonable, fair and just. It is an essential ingredient of reasonable, fair and just procedure to a prisoner who is to seek liberation through the court process that he should have legal services available to him. Free service to the poor and needy accused person is an essential element of any reasonable, fair and just procedure. This discussion can be concluded by mentioning that the right of an accused person to avail of legal service for his defense has now become clear and absolute, not only by the provisions of Code of Criminal Procedure 1973, the Constitution and the Legal Services Authorities Act 1987, but by various judicial decisions of the Supreme Court. The catena of cases before the Supreme Court has now made the right of the accused person to avail of legal service a settled human right and violation of which would vitiate the proceedings against him. The decision in Amir Kasab discussed above has made the provision of legal service more stringent. Their failure to provide legal service to needy accused person not only vitiates the proceedings against him, but to the extent of fixing the liability to the magistrates to be infraction of his duty and liable to departmental proceedings instituted against him. Not only that, the accused who was not provided legal aid at state expense is given the right to claim compensation against the state for the dereliction of duty of its magistrates Now it is hoped that the provisions work in letter and spirit in the best interest of the indigent accused persons. This much for today. Thank you very much.